I hope this finds you well. Today we look at a Supreme Court case decided on November 9th, 2015. The case of Mullenix v. Luna. The parties are petitioner Chadron Lee Mullenix and the respondent is Beatrice Luna as representative of the estate of Israel Leha Jr. This case concerned whether the District Court and the U.S. Court of Appeals for the Fifth Circuit was wrong in their determination that Mullenix, a police officer out of Texas, was not entitled to qualified immunity when he shot and killed Leha. The facts of the case are this. On March 23, 2010, a different officer made contact with Israel Leha at a fast food restaurant. The officer had an arrest warrant for Leha. Leha then fled the scene, leading police on an 18-minute high-speed chase. During the chase, Leha called the dispatcher and made numerous threats towards the officers, stating that he had guns and that he would shoot officers. There were 2 officers in pursuit of Mr. Leha, and spike strips were deployed at an underpass on the route Mr. Leha was on. Mullenix was not involved in the chase but responded to the chase and drove to the overpass. He then decided that he was going to shoot at the car Leha was driving in order to disable it. Mullenix had no training in this tactic or had ever done it before. Mullenix then informed his supervisor of what his intentions were by radio, but before he received a response, he took up position on the overpass. His supervisor then responded, I'm assuming over the radio, telling Mullenix to stand by and see if the spikes work first. Mullenix also discussed his plan with another officer on the overpass. 3 minutes later, he saw Leha's vehicle approaching. Mullenix fired 6 shots, 4 of which entered Leha's body. The car then hit the spike strips and flipped, and Leha was found dead in the vehicle. The death was from the 4 shots fired by Mullenix. So here's what happened. Luna then brought a civil rights action under Section 1983 for violation of Leha's Fourth Amendment by use of excessive force. Mullenix then moved for summary judgment, arguing that he was entitled to qualified immunity, but the district court denied the motion, finding that there were genuine questions of fact. Mullenix then appealed to the Fifth Circuit Court of Appeals, and the Fifth Circuit affirmed the district court's finding of no qualified immunity. The case then made its way to the United States Supreme Court, where the issue was recently decided in a per curiam opinion. The court chose simply to look at the qualified immunity portion of the case and not whether Leha's Fourth Amendment had been violated. The court stated that the doctrine of qualified immunity shields officials from civil liability so long as their conduct does not violate clearly established statutory or constitutional rights of which a reasonable person would have known. The court further stated that a clearly established right is one that is sufficiently clear that every reasonable official would have understood that what he is doing violates that right. The court found that Mullenix did have qualified immunity, reasoning that by the time Mullenix fired, Leha had already driven police on a 25-mile chase at high speeds, was reportedly intoxicated, and had twice threatened to shoot officers, and was racing towards an officer's location. The court also noted that the Supreme Court itself has never found the use of deadly force in connection with a dangerous car chase to be a violation of the Fourth Amendment. It's important to note that there was no precedent, per se, with the same facts as Mullenix, but the court did compare Mullenix's case to previous cases of excessive force. Justice Sotomayor dissented in this opinion, reasoning that the majority narrowly focused on the imminence of the danger that Leha posed to the public and didn't think that there was any justifiable reason for a reasonable officer in Mullenix's position to fire his weapon at a car as opposed to waiting to see if the spike strips that were laid out would work. She concluded that there was no government interest significant enough to outweigh that intrusion. In rebutting Justice Sotomayor's dissent, the per curiam opinion stated that spike strips present dangers of their own, not only speeds between 85 and 110 miles per hour, but also to officers manning them, seemingly stating that Justice Sotomayor's belief that the spike strips was a danger in itself. In conclusion, the court reversed the Fifth Circuit and found that Mullenix was entitled to qualified immunity for his actions, holding that qualified immunity applies to the actions of police officers who used lethal force against an intoxicated fugitive who threatened to shoot other officers and was in the vicinity of an officer, because the use of lethal force in this context cannot be shown to be unreasonable beyond debate. Thanks for watching, and I'd like to hear from you. Do you agree with the court's holding? Do you think this case gives officers too much discretion in high-speed chases? Or is the need to protect the public outweigh the danger of shooting at a vehicle? With all the attention given to excessive force recently, should the court have examined the excessive force side of things as opposed to confining its ruling to qualified immunity? Let me know in the comments below.